federal jury just ordered one of the largest designer handbag resale companies in the country to pay $4 million. Not because the bags were fake. Every single one was authentic, stitched in the same factories that supply Chanel boutiques. A string of numbers stamped inside the leather held the real problem, and those numbers told a very different story than the receipts did. And if you've ever sold a used designer bag online for profit, same numbers game applies to you. The company is called What Goes Around Comes Around, or WGACA, and for decades it built a business on a single legal assumption. Once Chanel sells a bag, Chanel loses control over what happens to that bag next. That assumption has a name, the first sale doctrine, and it's the reason second-hand stores, consignment shops, and eBay sellers can legally resell brand-name goods without asking permission first. WGACA leaned on it hard enough to become one of the biggest names in luxury resale, moving hundreds of millions of dollars in pre-owned handbags a year, while a smaller army of individual sellers built their own side businesses flipping designer goods on exactly the same legal theory. Then Chanel looked closer at the serial numbers, and a second question opened up alongside the first one. If a company with lawyers on retainer got this wrong, what happens to the person doing the exact same thing from their spare bedroom with no legal team at all? Every genuine Chanel bag carries a serial number sewn into an interior tag, a manufacturing fingerprint to track authenticity, not ownership disputes. In 2018, Chanel sued WGACA in the Southern District of New York, and buried in the evidence sat a range of numbers, 17,686,401 through 17,716,400. The Chanel's own factory records tied to a batch stolen out of a facility in Italy. WGACA had bought and resold bags from inside that exact range. Because Chanel never chose to release those specific bags into the market in the first place, the court ruled there was no first sale to protect. The doctrine simply didn't apply. But the stolen serial numbers weren't even the strangest find in the case. Investigators also turned up vanity trays, store displays, and counter gifts, items Chanel had manufactured only as promotional giveaways, built to a lower production standard than anything sold at retail, and never intended for resale at all. WGACA had sold those too, under the Chanel name. The court treated that as a separate infringement, distinct from the stolen inventory. A third category made things worse. Bags with swapped hardware, repainted leather, or altered structural pieces. Once a genuine item is materially changed, courts have ruled it stops being the same product Chanel originally sold, which means the first sale doctrine no longer has anything left to attach to. At this point, the case stopped being about handbags and started being about advertising. WGACA marketed items as 100% guaranteed authentic, language that sounds like a simple quality promise, but that courts have treated as something closer to a claim of brand partnership. Under the Lanham Act, the federal law protecting trademark owners from confusion and false endorsement, a reseller can use a brand's name to accurately describe a genuine product, a principle called nominative fair use. What a reseller cannot do is imply the brand itself stands behind the sale. In a related case, Chanel versus The RealReal, a federal court found that authentication guarantees like these can cross exactly that line, even when the products underneath really are genuine. None of this touched criminal court because WGACA was never accused of selling counterfeits. That distinction matters because the law waiting on the other side of it is far harsher. Under the Trademark Counterfeiting Act of 1984, intentionally trafficking in goods carrying a fake brand mark can carry prison time of up to 10 years for an individual, on top of corporate fines running into the millions and personal asset seizure. WGACA's problem was narrower and, in its own way, scarier for anyone in the resale business. You don't need a single counterfeit item in your inventory to lose in court. Genuine goods sold the wrong way are enough all by themselves. Here's the part that gets uncomfortable for the person reading this on their phone with a closet full of barely worn handbags. a license requirement sits underneath all of it, one that almost nobody selling used designer goods online has actually checked. And it has nothing to do with trademarks. It's a much older kind of law. Most independent resellers assume a state sales tax permit, the paperwork that lets you buy inventory tax-free and collect tax from buyers, is the only license commercial reselling requires. It isn't. In California, New York, Florida, and dozens of other states, anyone buying second-hand goods with the intent to resell them for profit needs a separate second-hand dealer license, issued not by a tax office, but by a police department, sheriff, or state department of justice. California requires fingerprint-based background checks through the state DOJ and daily electronic reporting of every acquired item. Serial numbers, brand names, seller identification, even a thumbprint, into a statewide database called CAPS. New York City requires similar reporting through a system called Leads Online, plus a licensing fee and a criminal background review every 2 years. Florida goes a step further. Dealers must submit full fingerprint sets to the FBI and hold every acquired item at their registered address for a set waiting period before it can be resold at all, giving police time to check it against stolen property reports. These laws were written decades ago to fight pawn fraud and stolen property, and secondhand luxury goods, handbags, watches, fine jewelry sit squarely inside them today. A California appeals court did carve out one real exception, ruling in a case called Hop v. City of Los Angeles that someone who simply buys and keeps used goods for their own collection without reselling them falls outside these statutes entirely. The moment profit-driven resale enters the picture, that protection disappears. Selling without that license isn't a paperwork slip. In New York, it's a criminal misdemeanor, stacked on top of civil fines running $500 to $2,000 for every day the business operates unlicensed. In Louisiana, unlicensed dealing can carry criminal fines up to $5,000 and 30 to 60 days in jail. In California, a law passed in 2013 lets prosecutors treat unlicensed, unreported secondhand dealing as organized criminal profiteering, which opens the door to seizing not just the inventory, but the business's profits entirely. Federal law has started paying attention too. Once an online seller crosses 200 transactions or $5,000 in a 12-month period, the Informed Consumers Act requires the marketplace itself, eBay, Poshmark, whoever hosts the listing, to verify that seller's tax ID, bank account, and address, and hand that information over to authorities on request. None of this reporting infrastructure is theoretical. In Gem Financial Service versus City of New York, a licensed dealer went to federal court arguing the NYPD had no right to demand daily electronic uploads of every transaction. The court disagreed and upheld the city's authority to require it. The second-hand market all of this applies to is on pace to hit $74 billion in the US by 2029, more than 18,000 times the size of the fine that just leveled WGACA. And every one of those dollars is now easier for regulators to trace than it was 5 years ago. A federal court spent the better part of a year determining whether a quilted handbag with swapped clasps counts as the same legal object it was before someone swapped the clasps. American jurisprudence, moving at exactly the pace you'd expect. The jury reached its verdict in February 2024. $4 million. Not for selling fakes, for selling real bags the wrong way. Stolen serial numbers, unreleased promotional items, altered goods, and advertising that promised more than the law allowed. 4 separate legal failures. Any one of them would have been enough. $4 million is roughly enough to cover full in-state tuition for 100 students at a public university, 4 years each. That's the size of the bill for getting the fine print wrong. This is what carries over to anyone reselling on a smaller scale. If you're buying designer handbags, watches, or jewelry specifically to flip them for profit, even from your kitchen table, even only through an app, most states already classify that as secondhand dealing, not casual selling. A one-time garage sale of your own old things is exempt in most places, as long as it's occasional and the items were bought for personal use, not resale. A recurring business built around acquiring inventory to resell is not exempt, regardless of whether you ever open a physical store. The line isn't where you sell, it's why you bought the item in the first place. And the moment your resale account crosses 200 sales or $5,000 in a year, the marketplace hosting you is federally required to start verifying who you are, which means the paper trail already exists before anyone has to come looking for it. If you're already running a resale side hustle, this is worth a real conversation in the comments. Had you heard of a secondhand dealer license before this? Or did you assume your tax permit already covered it? Subscribe if you want the rest of these legal blind spots before they cost you $4 million of your own. Next week, the single clause buried in almost every consignment store contract that lets the store keep your item indefinitely the moment they claim it arrived damaged. And why? In most states, you have almost no way to prove otherwise.